Good afternoon. One of the important judgment coming from Kerala High Court, Indian Medical Association, and the Fact and Issue Watch, whether GST leviable on supply of services by a club or association to its members. There was an issue for the constitutional validity of Section 7, subsection 1, clause AA, which was retrospectively inserted by Finance Act 2021, but made applicable from July 1, 2017. And as per this clause, an explanation thereto, read bit section 2, subsection 17, clause E, activities or transaction by a person other than individual to its members or constituents or vice versa for cash, deferred payment, or other valuable consideration was considered as supply of services and made chargeable to GST, that too with retrospective date, July 1, 2017, as per this Honorable Kerala High Court judgment. They have strikes down the constitutional validity of this provision. Further held that this provision is nullifying the principle of mutuality, which was decided and dealt in detail in the Calcutta Club Limited by the Apex Court. And I've jotted down 7 important pointers which is coming out from this judgment worth noticing whenever we talk about supply of services by club or association to its member, whether chargeable to GST. Of course, in pre-GST era, for service tax chargeability, we got Apex Court judgment, Calcutta Club Limited, but GST, this was the disputed point, because provision got inserted retrospectively from July 1, 2017. And look at single member bench has said it is a supply of service chargeable to GST, but division bench has allowed the appeal filed by IMA against the single member bench judgment. So 7 important pointers. I'm showing those 7 pointers to you. Let me share my screen. The first important point, as I have said, that Honorable Kerala High Court has struck down the constitutional validity of Section 7, subsection 1, clause AA, which was retrospectively inserted, read with the explanation thereto, along with the definition under Section 2, subsection 17, clause E. Constitutional validity, they have struck down. Second point, these provisions, which was retrospectively inserted, are nullifying the principle of mutuality, which was expounded in the Supreme Court judgment of Calcutta Club Limited, and even stated, because this principle of mutuality got survived even after 46th Amendment to the Constitution of India in 1982, which talks about deemed sell. Third point, the concept of supply and service as mentioned in the GST, what requires plurality of person. So the concept which was discussed on the concept of principle of mutuality, that you can't provide service to yourself. So there has to be plurality of person whenever we talk about supply or service. Next, it is being stated, as I have already concluded, that Section 7, subsection 1, clause AA, read with Section 2, subsection 17, clause E, an explanation thereto. They have said these are declared as unconstitutional and void because ultra vires the provision of Article 246A, which is giving power to both central and state for GST law. Even it is violating the Article 366(12)A, which is GST. What is the GST? What is the meaning of GST? And then Article 265 to the Constitution of India, which is talking about taxes should be collected with the authority of law. It is violating. That's what it is being held. Further, on retrospective effect, because these provisions got retrospectively inserted, then what is being said, and it is important to note, worth noticing. They said when parties have not anticipated such for the past period, it's against the fairness and the rule of law. Quite obvious. When you're inserting this provision by Finance Act 2021, making it applicable from July 1, 2017, is it not going against fairness? Is it not going against rule of law? And quite obvious, such club and association might not have collected the GST component when they have provided the service to its members. So it is going beyond this fairness concept on retrospective effect. Further, it is being stated, and this must be taken a note of it. This is important and must be taken care of whenever any legislator is making the law, whether it is within the framework of law and within the Constitution of India. Read what is being stated. That state is obliged to offer justification for all its action that touch upon the constitutional rights, fundamental and otherwise, of its citizen. We do not find any such justification for the retrospective operation of the impugned statutory provision. So this was the point held in that said judgment. But the interesting one, so it is for the retrospective, whatever we are discussing. Question will come to your mind whether it is prospectively applicable. In that case, what is being stated, the court said, as long as Calcutta Club remains as a binding precedent, which talks about principle of mutuality, and even survived after 46th Amendment to the Constitution of India in 1982, which talks about deemed cell. So as long as this Calcutta Club remain as a binding precedent, or the Constitution is not amended suitably to remove the concept of mutuality from the concept of supply and service, the amendment to the CGST, SGST Act should fail. So even prospectively, it can't be applied till the time the law is being made as per the Constitution and Constitution to be amended appropriately. Otherwise, Calcutta Club principle of mutuality remain as a binding precedent. So division bench allowing IMA appeal against the single member bench order, and single member bench hold that IMA supply of service to its member is taxable to GST, which is now being done away. And it is being stated it is unconstitutional and void. It's a very good judgment. You may read the full judgment. Description box is having full judgment with the crisp point, whatever I've discussed in this particular video. Thanks for watching. Stay tuned. Thank you very much.